Great. I think we've got a good number of people in now, so we will kick off. Thank you very much for joining us today for our ThinkHouse session. And we're going to be looking at grant versus contract. Just some housekeeping points. We're scheduled for about an hour today, but hopefully we'll have some time at the end to mop up some questions. There is a question and answer function available, so if you've got questions as you go through, please do pop them in that, and we'll try to get to them at the end. Just in terms of introductions, I'm Alexi Markham, so I'm a partner in the commercial IT and outsourcing team at Gowlings, and my focus is very much on the government sector and the wider public sector. I'm joined by Chris, who is a public support lawyer and also a legal director specialising in public procurement. In terms of the agenda today, so we are obviously looking at grants versus contracts, but it kind of splits down into three main topics. So firstly, we're just going to be looking at what is a contract and what is a grant and what are the key differences between the two. And we're going to be probing some of the factors that you need to be looking through to sort of decide which is the correct funding route for you. The second part of the session is really looking at if you find yourself in the grant territory, what is the governance regime that applies, and what are the sort of things that you need to be thinking about. And then finally, the third part to the session hopefully will be a little bit more interactive. We're hoping that IT is on our side today, fingers crossed for us. And we're just going through some examples and trying to sort of apply the framework that we've just talked through to try to determine whether something's best suited to be a grant or a contract. And then as a bonus session, Chris is just going to give us an update on the procurement bill at the end of the session, because I'm sure that's high up on everyone's lists. Okay, so I shall hand over to you, Chris.
Thank you very much, Alexi. Good morning, everyone. Nice to see you. Except, of course, I can't actually see you, but it's nice to know you're all tuned in and watching us here. So from me, first of all, key differences between a grant and a public contract. And for a number of us, I'm sure this perhaps is an issue that we might have come across in the past. You know, we have some planned funding, a public body paying for something or funding something. How do we actually know whether or not we are dealing with a grant or a public contract of the type to which the public procurement regime might apply? Because, of course, there's a world of difference in the consequences of the answer to that question. So in this session, we're trying to almost split that out and kind of explain where and how where the differences lie and how to sort of spot them. So first of all, then, basic features. A grant, a funding commitment from an awarding authority, a grant awarding body, a funding body, to some recipient, some sort of recipient, whoever that recipient might be. And in a grant agreement, we have funding, which enables a recipient meeting, I suspect, eligibility criteria of one sort or another to fulfill some kind of project or activity that is going to benefit someone somewhere, benefit the wider community, or achieve a policy objective of some sort. On the other hand, a public contract of the type to which the procurement regime applies is a rather different kettle of fish. These are defined in the Public Contracts Regulations 2015 at Reg 2 as contracts for pecuniary interest, which means payment or consideration of some sort, concluded in writing between economic operators, that is suppliers, businesses, who are to provide a service or supply goods or carry out works, and one or more contracting authorities, and which have as their object the execution of works, the delivery of a project, the supply of products, goods, or the provision of services. So a much more commercially oriented, if you like, arrangement. Payment by an authority to an economic operator, a business, to supply goods, services, or whatever. A grant has to be justified based on the activity that is being undertaken and the benefit that it will generate for the community or to achieve that policy objective. The awarding of grants is subject, as we'll see later, to certain cross-government standards and requirements, and Alexei will explain more about that partway through. Competition should be considered, needs to be considered. A public contract, I suppose, on the other hand, we could call the default route in terms of ordinarily when an activity is being provided by the private sector to the public sector, to the public purse. The default is perhaps the procurement route, and we could perhaps characterize grants as maybe more of a sort of a specific exception to that. Public contracts are, of course, as we know, subject to procurement rules, so tendering processes, evaluation criteria, principles, fairness, transparency, treatment, and so forth, all applying, whereas in they don't apply in the same way in the grant sphere. And of course, when it comes to public procurement, competition is mandatory when the expected value of the contract exceeds a certain threshold. Next slide, please. So if we drill down into some of that a little bit, what perhaps we ask ourselves next are the key features, or might there be key features when we're presented with a document or some sort of award proposal that might point to it being a grant or point more to it being a contract, a procurable public contract? Well, here are some. First of all, factors that point towards a grant are, we would say, a situation where the authority doesn't directly benefit. So it doesn't have a direct economic benefit that accrues to itself. The benefit is much more out there in the community in terms of the end result achieved from the funding. And indeed, when it comes to a grant, it's important that there is not any direct economic benefit to the authority. Otherwise, it's more a public contract. The absence, of course, of factors which might point towards a contract. We'll deal with that on the next slide. The recipient of the funding in a grant situation tends to be required to put the sums to a particular use, to apply them in a particular way towards the achievement of certain results and objectives. There is an absence of any particular requirement to supply services. So things aren't perhaps couched in a grant funding agreement in the same way as they would be in a public contract with absolute obligations to supply services, KPIs, invoicing, and so on and so forth. All those typical hallmarks of a public contract. Outputs being provided free to the public. So that it's very much the public, the community at large that benefits. And of course, key in a grant, clawback in the event of the funding recipient misapplying the grant, or perhaps receiving it as a subsidy, or as what we used to know as state aid. Also, watch out, you need to ensure the authority awarding a grant has the legal power to do so. Might be worth checking. Next slide, please, Lexi. By contrast, then, some factors which point towards a public contract are a direct economic benefit accrued to the authority. Performance obligations being imposed on the provider, on the recipient of the payment, to which the recipient of the payment wouldn't be subject if it were merely in receipt of a grant. Thirdly, a direct link between the services provided and the money given. Therefore, no services provided, you don't get paid. And of course, this characterizes the money as consideration for services rendered, services provided. The activity, of course, being commercial in nature. And the payer, i.e. the authority, being able to sue for breach of contract if services aren't provided, usually to its satisfaction. Next slide. What about payment provisions, specifically, and how those differ from contract to grant? Well, we'll see a few features of the payment regimes that apply to both, listed there on the left-hand side of this slide. And we can see when we read across the slide how they differ between contract and grant. So what about profit? In a contract, the provider can make a profit. In a grant, the funding provided isn't intended to do that. It's only intended to cover the recipient's costs. Clawback services are retained by the provider in a contract, whereas in a grant, surplus might be clawed back. And of course, there is generally going to be an ability to claw back fund, as I've said before, that has been misappropriated or is misused, misspent. Payment under a contract tends to be in arrears by results on an invoice, on production of a valid invoice. Well, in the grant situation, the recipient doesn't really invoice as such. It's more drawing down or claiming installments of grant. Sometimes that's made in advance. Sometimes it's on achievement of certain milestones and objectives. Funding risk, very much on the supplier in a contract situation, but retained by the authority in a grant. And the permitted use. Well, what happens if in a contract in terms of what the provider, the supplier, can do with its money? It can spend it as it chooses. Whereas in a grant, very different. The provider may only use the funding that's been provided for the objectives of the project and for no other. Next slide. Thank you. What about performance obligations? And again, here we've listed on the left various facets of this. Outputs, KPIs, management, contract management, benefit and enforcement. And again, these differ. In a contract, there are clear specific outputs that need to be delivered, KPIs, service deliverables, whereas a grant is perhaps framed differently. That tends to be focused much more on supporting a policy objective or fostering a general outcome, albeit, of course, subject to various conditions. In contracts, we see service levels, KPI regimes, service credit regimes, liquidated damages, and so forth. Well, we don't really get that in a grant. There, we tend to rely perhaps more on reporting requirements and on information streams where the recipient has to tell us how it's putting the money to good use or to the intended use, the required use, and how it is achieving the objectives of the grant. Management might be much more authority-centered in a contract, whereas in a grant, the authority is likely, I think, in most situations, to have much more limited control, and it tends to be up to the grant recipient to make sure that it is delivering the required outputs, otherwise there might be clawback. The direct economic benefit in the contract, of course, accrues to the authority, whereas in the grant, that doesn't happen. We don't really talk of a direct economic benefit there. And of course, what about enforcement? Well, in a public contract, an authority can, of course, sue the economic operator if there is poor performance or the outputs, the service, whatever, isn't delivered. the goods aren't delivered. Whereas in a grant, it works somewhat differently. The authority has no remedy for a failure to achieve the objective, other than perhaps to get any money back in terms of clawback. So why is the distinction key? Why is it important? Well, it's important because if it's got wrong, if the distinction isn't correctly drawn, then there can be various implications. So, for example, tax, VAT in particular, grants fall outside the scope of VAT, whereas public contracts don't. Procurement, as we know, grants aren't procurable within the ambit of the public contracts regulations, the public procurement regime, whereas public contracts, of course, are. And as we already noted, enforceability, grants, generally speaking, tend to be unenforceable against the funder unless executed as a deed. But of course, there is clawback in there, as you'd expect, in relation to enforcement against the funded body, the recipient. Next slide. And what are the legal risks then of getting it wrong, of getting this distinction wrong? First of all, VAT claims. I'm struggling to think of procurement cases where the particular point in issue has been a misclassification of a public contract as specifically a grant. But that is much more the centre of attention when it comes to VAT claims. That does tend to be a bit of a feature of VAT claims. Public procurement risk. Public contracts, of course, as we know, over the thresholds have to be competitively tendered, competitively procured in order to ensure equal treatment, the rest of it, and of course to achieve value for money. Whereas, of course, grants are not. And if the distinction is not correct, then an authority might find itself directly awarding, mistakenly thinking it's a grant, what is actually a public contract which should have been publicly tendered. JR is still potentially an issue, even when we're squarely within the grant space, because there are certain procedures which accompany the awarding of grants, certain procedural requirements, notably in the form of the Cabinet Office grant standards. And it is possible that one could see a judicial review claim for failure to follow the decision-making procedure laid out in the Cabinet Office grant standards. Then, of course, the subsidy control, or what we used to know as state aid. In order to be classed as a subsidy, a grant would need to meet certain criteria, and those are on that slide. It is possible that a grant that is misspent or perhaps isn't awarded following the requisite homework or due diligence could end up being or operating as an unlawful subsidy on the recipient, if the recipient is the type of recipient that could be placed at a competitive advantage as a result of having received subsidy in the form of a grant. And so for that reason, when one comes to awarding grant funding agreements, there is usually care that needs to be taken to make sure that no subsidy is being conferred. And I think with that, I will, yes, hand over to Alexi to take us through the next few slides.
Thanks, Chris. So now Chris has put the scarers on about what happens when you get it wrong. I just wanted to pick up one last point before we get onto the governance regimes around grants, and that's just about legal powers. So Chris, you've alluded that in order to make a grant, then you have to have a correct legal power. And on the slide here, we've just set out some of the common powers that are used at central government. So the Local Government Act, the Charities Act, the Housing Grants, Construction and Regeneration Act. And I think the important thing here is just to flag that you need to speak to your internal GLD lawyers, and they usually will sort of check that you've got the right legal powers in place, and then you need to record that in your business case, and also we tend to record it on the grant agreement as well. So that's what we want to say about that. So having gone through all the factors that Chris has just outlined, and got yourself comfortable that actually you should be looking at a grant for the correct funding mechanism. Sometimes we find our clients think, oh, phew, we're home and dry, we're outside of the public procurement regulations, actually this is going to be easy, but actually unfortunately that's not the case any longer. So in 2006 the Cabinet Office brought out its grants functional standards, and this was very much a reaction to the lack of sort of regulation in this space before. So on the collapse of Kids Company back in 2015, there was a PAC inquiry looking at some of the financial management that went wrong within that organisation, as it was sort of wholly funded by government grants. And as a result of that, they brought out this very useful standard, which is aimed at trying to get some consistency across the different government departments as to how grant governance work. In terms of what it looks like, it's essentially 10 minimum requirements, each of which that focuses on a particular area of grant making, and those are summarised on the slide here today. So you get a sort of high level summary of what the minimum requirement is, and then for each of those you get a quite useful, more in-depth guidance notes that sort of goes into the details of what that looks like. So I'd strongly encourage going onto the Cabinet Office website and finding that guidance. We are not going to look at all of these today, but what I thought we would do is just pick up on some of the ones that are of particular interest to lawyers. So we're going to look at the approvals process, which is minimum requirement 2. We're going to look at robust business case, which is minimum requirement 4, competed by default, minimum requirement 5, and then obviously robust grant agreements, because we love agreements. Minimum requirements 2 and 4, which is robust business cases and approvals process. So grants are generally left to be determined in accordance with the organisation's own governance and management framework. However, the minimum requirement does sort of set some limits around that, and I kind of summarised that on this particular slide. And there's a sliding scale depending on whether the grant's determined to be low risk or low value, or high risk and high value. And that also sort of, it points to who might need to approve the business case, but also points to the level of detail that would be required in the business case. In the context of legal advice, the key things that we typically get asked to input into business cases around the legal power to award the grant, which is something we've just touched upon. We typically would give a legal assessment around the subsidy control risk, which Chris talked about. We'll give a legal assessment around the procurement risk. So should it have been competed as a public contract rather than a grant? And then your GLD lawyers will input into the public sector equality duty. So have you had due regard to the impact that the grant will have on equality considerations? Competed by default. So this is the key message here, is just because it's a grant and just because you're outside of the public procurement regulations and you don't have a strict legal regime that you have to follow in terms of competing grants, the policy is very clear that direct awards are not the norm. Grants should be competed, and that is needed to help demonstrate value for money, to meet the public duties of transparency and fairness. There are instances when a direct award of a grant can be justified, and the examples of that might be if there's only one provider within the marketplace who's capable of delivering the activities in questions, or it could be a situation of extreme urgency which hasn't been caused by your own fair hand. So you can see the exemptions are starting to look very much like what you would find under Regulation 32 of public procurement regulations. And I think the important thing is, if it is a direct award, you need to get approval, and you need to be very clear in the business case that it is a direct award and why that's appropriate, and what you've done to sort of mitigate any risks around things like value for money, transparency and fairness, given it as a direct award. The guidance, so minimum requirement 5, isn't particularly prescriptive about what that competition looks like, so you've got a lot more discretion than you would have under the procurement regulations, but there is some sort of helpful pointers in there. But essentially the key thing here is, when you set out prospectus, you need to be quite clear about how you're going to be evaluating applications, and then you need to apply the evaluation criteria consistently. So do what you said you were going to do. So minimum requirement 6 then is around a robust grant agreement. And the good news here is that the Cabinet Office have got a template grant agreement, and if you use that, then I'd say you're sort of 80% of the way to having a robust grant agreement, because it sort of picks up on all the key risk areas, so things like subsidy concerns, and making sure that you've got the right visibility in terms of things of fraud and use of funds. We are going to just pick up on a couple of the features now, but as I said, I would strongly point you towards that template in the first instance. So what do we need to build into a grant agreement? Firstly, a clear description of expenditure. So what can the money be spent on? And equally important is ineligible categories of expenditures, so things that you're not allowed to spend money on. So typical things there would be political purposes or lobbying, for example. Payment, just like a contract, it's important to understand when the monies are going to be paid. Will they be paid in one lump sum up front, or are you looking at tranched based on some sort of delivery, and so meeting milestones? And just tying back to what Chris said earlier, do focus on the language. It should be drawing down rather than payment, just to make sure that you're firmly in the grant camp. Reporting is really important, so that would be both financial reporting, so how the money has been spent, and delivery based reporting, so how is the provider progressing in terms of meeting the desired outcomes of the grant. That tends to be sort of quarterly and annual, and then there'll be an impact and valuation at the end of the grant funding. Counter fraud policy. Fraud is obviously a big concern when it comes to grants, so the grant agreement should have some provisions that facilitate the identification of any fraud, and then the rapid escalation and potential termination of the contract in those instances. Audit insurance, again, hopefully you've got good reporting, but if you want more comfort having looked at the reporting, then typically the grant agreement would allow you to sort of request the invoices to back up the reporting, and potentially put in an auditor to confirm that everything's accurate. Subsidy compliance, we tend to sort of build in a right to terminate the grant agreement in the event that the payments found to be an illegal subsidy. And then the key thing here is remedies. They're not remedies in the normal contract sense, in that you don't get damages, but what really you're looking at is things like what can you do if you've got a concern that the grant receiver is not complying with the terms of the grant agreement. So you'll want to be able to pay, suspend any future payments of the grant, and then potentially you'll want to be able to terminate and claw back some of the grant that's been given today. And that might be just unspent funds, or if you're terminating for something like fraud, you might start to want to claw back spent funds as well. Talked about impact evaluation, and then finally data sharing and data protection. due to the nature of grants, it often touches on sort of individuals and the public at large, and it's often in terms of trying to understand the impact, important to sort of have data that can contain personal data. So it's important at the outset to sort of understand what data needs to be collated in order to understand the impact of the grant, and then understand who's going to be responsible for collating that and who's going to need access to it, and that would then inform what you need to put in there in terms of data protection provisions. So who's going to be the data controller, who's going to be processing what you need to put in there to be compliant with the Data Protection Act, and it might be that you need a separate data sharing agreement. That's quite common with grants, but it's just something to make sure is on your radar as such. Okay. So this is the interactive bit, which I'm nervous about with the IT, but essentially what we thought we'd do now was just try to sort of apply some of the concepts and the framework that we've just talked about, and get you to answer whether you think some of the activities listed on the screen are a contract or a grant. So number one, local authority providing funding to plant trees. Number two, funding for running IT workshops in a disadvantaged area. Number three is funding to create a COVID symptom app. And then number four is funding for a museum and visitor information centre. Hopefully, IT allowing, we should have a poll pop up in a second. So if you can just complete that poll with your sort of gut feel for which would be the right funding mechanism, and that would be great. Oh, something's gone. There we go. We'll just give you a minute or so to do that. Okay. We shut that down now, KJ. Perfect. All right. So we'll go through them now, I guess, in a little bit more detail, because I think as you'll hopefully know from what we've talked about today, there's more questions you're probably going to need to ask in order to determine it. So number one, local authority funding to provide to plant trees. So the winner on this one is a grant, and I'd agree, my gut reaction is a grant, but what do we think are some of the questions? And if you could just pop this into the Q&A that we need to ask in order to sort of test that that initial reaction. Any thoughts, or shall I just jump in with my questions? Here we go. We demand a planting 100 trees. It can be a contract. Is it on private or public land? Yeah, very good. So yeah, so basically, there's, in terms of using the frameworks, you want to understand the nature of the obligation. As you said, are we demanding the planting of the trees, or is it more generic? Where do we want them planted? If we want them planted on the local authority land, and then that's probably going to be a direct benefit to the local authority, whereas if it's just in the community at large, then that's a benefit for the larger community. So assuming that it is just for the benefit of the larger community and it's doing it to improve the quality of life for its residents, then it feels like a grant, doesn't it? But the one watch out point then and here is just about whether the legal authority has an obligation under law to plant those trees itself. So if there was some sort of central government legislation that said compelled local authorities to plant the trees, and that would then look like it's outsourcing its own obligations to a third-party provider, and that would put it back into the grant territory. Cool. So question number two then, funding for running an IT workshop in a disadvantaged area. So here we've got 59% say grant and 32% say contract. So again, questions around what we think we need to sort of ask to determine which is the correct answer. You can just stick them in the chat. Yeah, so we got can be either depending on whether you demand it. Yeah, so again, is the output free for the public? Grant, yeah. So yes, we need to look at the nature of the obligation. So, you know, are we requiring that the IT workshops provided in a specific venue? Is it a school? Is it a community centre? And that doesn't necessarily mean it needs to be a contract, so it could just be a conditioned grant, which is fine, but it's helpful to understand, and also it's helpful to understand who the provider is. Is it a not-for-profit organisation or is it a for-profit organisation? The key thing is just trying to understand the benefit. On the face of it, it doesn't seem like the department would be getting anything in return. So the IT workshops for the public, it's not for its own employees, for example. So it kind of feels like a grant. But again, the one thing to check there is just that point around, is the organisation under an obligation to provide those workshops itself? Because if it were, then that could push it into the contract category again. So the third one then, funding to create a COVID symptom app. So here we've gone 73% contract versus 16% grant. And yes, I would say on the face of things, that does look like a contract. So any sort of questions around what we'd need to probe on that one? I'll just dive in, I think. So it's an interesting this one because I think it could probably go either way. So in terms of what the nature of the obligations, you're wanting to understand really, you know, what happens if they don't provide that app. If the app's not up and running, would the funding organisation want the ability to sue, or is it just they're trying to facilitate the production of that app, but there's not necessarily a hard obligation to provide it, and there's no service levels in terms of things like uptime? Understanding the market's going to be important on that one. So is it a not-for-profit organisation or is it a profit organisation? And again, that's not determinative, but I think if you know it's a commercial organisation, so a for-profit organisation, sort of points it towards the contract piece in a bit more detail. And then I think in terms of the benefit, I think that's going to be really key here. So trying to understand what happens with the data from that app. Is the data going to the public at large, and it's just useful that data is available to the government, or is that data just going to the government? And equally, things like intellectual property rights. So what's the branding that's going to be put on the app? Is it a Department for Health app, or is it a third party app? And then obviously, one way or the other, you're going to have to think quite carefully about subsidy control on that particular one. And then the final one, funding for a museum and visitor information centre. We've got kind of 57% grant, and this is an interesting one. So when you apply the framework, then the nature of the obligations, obviously, funding a museum and visitor information centre, does it benefit the authority? Probably not. It's for the public at large. Kind of feels like it should be a grant. Is it a public or a non-for-profit or a profit provider? This one was non-for-profit, but actually this is one of the cases that got taken by HMRC up to court, and initially it was found that it was correctly categorized as a grant, but on review, the court found that actually it should have been a contract, and the reason for that was because of the language used in the grant agreement. So it was very much phrased in the way that a contract would be phrased. So there was sort of quite firm requirements around what needs to be delivered, and they were categorized as services, and there were opening times and really specific sort of obligations, and equally the payment was written in the way that you'd write a contract. So they wouldn't get paid if they didn't deliver, and it was talked about as being in consideration for the services. And equally, there was no restrictions around what the Museum and Visitor Information Centre could use the funds for, which again looks a lot more like a contract than a grant. So I think that one would just add it to the slides just to really underline the point that even if you've got something that should be a grant, you can get yourself into trouble unless you sort of structure it in the way and use the right terminology. So hopefully going back to some of Chris's slides about that will help you mitigate that risk. So in conclusion then, it unfortunately is not one of those areas where we can give you sort of a black and white answer. There is quite a lot of grey in the middle, but hopefully we've given you a relatively useful framework to think about in terms of classifying whether things are contracts or grants. And some of the key points there that you want to draw out is, what is it you're trying to achieve? How specific is it? And what do you want to happen if that doesn't happen? Really importantly, will the outcome directly benefit the authority? If it does, then you're looking at a contract. If it doesn't, then you could be looking at a grant. Do you have the legal power to spend the money? Because if you don't have the legal power, then procurement's going to be your only route. And then finally, it's about knowing the market. So have you looked out to the market? Do you know who potentially would be interested in those services? Are they likely to be commercial entities or not for profits? Because obviously those commercial considerations are going to put you down one route or the other. That is that. So Chris, I'll just hand over to you then for an update on the procurement bill.
Thanks very much, Alexi. Yes, so only a very brief update from me, because there isn't that much to say really at the moment. Other than that, the latest version of the bill is available on the Cabinet Office's website. The timetable, as far as we know, is that the aim is to implement the regime in 2024. We don't think it's going to be this year, but I would have thought that by this time next year, the bill ought to be law. So perhaps early spring 2024 looks like the direction of travel at the moment. As far as we know, a 6-month, or the previously talked about 6-month transition period, or sort of teach-in period from the old regime to the new, is still going to happen, still anticipated. And we expect there to be lots of supporting materials issued, not only by government, but also we'll be keeping a watch on that and doing our own set of further updates at this end. It isn't yet known when the bill is likely to receive royal assent. However, it is now at the report stage in the House of Commons, having already gone through all the stages in the House of Lords. There will be a third reading after the report stage, and then the set of stages in the Commons will be complete. If there are any amendments following the third reading in the House of Commons, then we expect that the bill would go back to the Lords to be approved before then receiving royal assent. So I suppose if I were a betting man, I might say that perhaps royal assent we could have that by the end of the end of the summer or the early autumn, and then the 6-month lead in perhaps before the bill is then implemented early next year. That's all I was planning to say on that. Obviously, we'll keep you abreast of developments. Okay, with that, shall we, we've got a few minutes left. Is it worth, Alexi, do we think, having a look through some of the questions and seeing whether we can answer any on the spot?
Yep, that sounds like a good idea. So look here then. So what is your view on grant recipients trying to insert force majeure clauses into a grant agreement? I think that would be a little strange, because force majeure is very much a sort of feature of a contract, and actually the obligations aren't hard in a grant agreement. So I don't really understand what would they be trying to achieve there. To the extent that there's some sort of force majeure that has an impact on the delivery of the grant activities, then they're not going to be sort of held to account in the normal legal way, in terms of they can't be sued for damages for non-delivery. But what it might impact, I guess, is just the payment profile. So yeah, I wouldn't typically expect to see a force majeure clause in a grant agreement, but very, very happy to be corrected on that. What else have we got? Other provisions you see grant recipients trying to assert into grant agreements that you would push back on the basis that they could risk putting the agreement into contract for services territory. I guess that probably goes to some of the stuff in your slides, Chris, doesn't it?
Yeah, absolutely. I think quite a lot of this area is perhaps fairly nuanced in a way, and you may well kind of depend, at least to an extent, on how you frame some of these requirements. So the first thing I suspect you can do is to avoid some of the language classically associated with public contracts, such as invoicing, performance regimes, KPIs, anything like this, or indeed perhaps even calling the outputs services, because of course there are certain vernaculars which do tend to kind of sit quite squarely within the public procurement regime or within the public procurement territory, and if you can avoid those and some of that language, then it's fine. Then that at least is good. However, I think substance over form is always the mantra here, and you really do have to make sure that what you're getting as the funding body at the end of the day isn't a service for which you're paying. You need to make sure, therefore, that the direct economic benefit doesn't accrue, and that the outputs of the grant do look much more the other way, at fulfilling a public good or a policy objective. I suppose if that is the starting point, and that's where you're going anyway, well then it's much easier to make the arrangement work as a grant, and to make sure that it's not straying into the public procurement regime. Yeah. But it's all about it's substantively avoiding the direct economic benefit, I'd say.
Yeah, and I think the one we do see sometimes is the whole piece around what suppliers don't like is they don't like the level of visibility that you need to have around grants for purposes, and obviously for value for money and understanding how the funds have been applied. So if you're giving a grant to a commercial organisation who's typically used to contracts, we sometimes find quite a lot of pushback around that sort of whole audit piece and that visibility piece. And also there can be a bit of mindset difficulty in terms of keeping the surplus and making profits. So they sort of think that we're getting this money, we can use it for what we want, and the whole piece around surpluses being clawed back seems to be a bit alien, and that typically happens at the end of the financial year. So we do tend to have some sort of interesting conversations around that. But that, as Chris was saying, you look to the substance, and that's key really to one of the distinctions. So it is important that those rights are sort of built into the grant agreement. Right, any other questions? Do you have any drafting tips where we government give grants to recipient who's then using that money to make onwards grants? Yeah, it kind of depends on who you're giving it to, because I think the convention, if you're giving the money to local government, then local government should be left relatively free to sort of spend the funds themselves. But assuming that we're not talking about local government, we're talking about some sort of third party outside of government full stop, then I guess it would be about visibility for me. So making sure that you've got the flow down of the audit rights that you want and need. You might want to include some provisions in there about how they sort of make those decisions about the onwards grants, like how do they compete those. Chris, I don't know, is there anything you would add to that?
I don't think so. I think I'd agree with that. Yes, I don't think I've got anything I particularly want to add, other than to say, yeah, all to bring very valid points. I think there is just one more question I think I can see right at the top. Apologies for the daft question, but when and why would a grant be executed as a deed? Well, first of all, I suppose no question around this whole area is ever daft. I think a perfectly worthwhile and valid question. Alexi, do you have any view on that?
I think it's quite unusual. Like we don't typically see it because it's unhelpful in some respects towards the government. So I think if you just had a commercial operator that was particularly nervous about having confidence that the money would come, I guess that might drive you down that road. But I'm trying to think. I'm not sure when I've done it that way.
Just thinking back, actually, I've looked at quite a few grant agreements in my time to sort of make sure they are grant agreements rather than public contracts. And I don't think I've seen one, can't recall seeing one executed as a deed. That has been decided to be executed as a deed for, I'm sure, those reasons. So I think, yes, I think generally speaking, you probably would expect for them not to be. Yeah.
Okay. So scrolling down, then I was unclear about something you said earlier. If a local authority is obliged to provide IT workshops and it sources this obligation, is that likely to be a grant or contract? So that would be a contract. So essentially, if you're an organisation and you're legally obliged to provide something, then if you get someone else to provide it, that will be a direct benefit to you because you no longer have to provide it, which then pushes you into the contract territory. Hopefully that's a bit clearer. The case that we're discussing, so that case was Woking Borough Council and Woking Museum, and we can actually, we've got quite a useful table of the cases which Chris sort of alluded to are mainly HMRC cases, so very happy to sort of circulate those after the session to everyone attended if it's helpful. What else have we got?
I can see another one here, which is a more procurement-y type question. Thanks for the session. Please could you say a little more about how an economic operator could bring a challenge under the public contract regulations where the authority has directly awarded a disguised public contract which purports to be grant funding? Yes, we certainly can say a little more. This is a situation where what the challenge would be from the economic operator would be doing would basically be challenging an illegal direct award. So if in substance, and again, this is all part of making sure the distinction is achieved between a grant and a contract, because if in substance the arrangement is actually a public contract, and has been misclassified either willfully or not as a grant, when in substance it is a public contract, and it is then directly awarded, then technically you have an arrangement which is challengeable on the basis that it is an illegal direct award and should have been subject to the public contracts regulations. This, of course, assumes that the value of the contract is above the relevant threshold. But technically, and certainly historically, illegal direct awards of procurable public contracts are basically about the most serious breach of procurement law, it's possible to commit. And it's for that reason, of course, that we have, potentially the ineffectiveness remedy. Not that there have been that many of those, but it is technically a possibility, at least in theory. These things, of course, tend to depend, or whether this sort of challenge scenario might arise is going to depend in reality on whether anyone actually hears about it. Because, of course, direct awards, by definition, tend to be under the radar. And so, obviously things do get out, but whether in reality a challenge arising would be less likely than a challenge succeeding if it were to arise. Well, that's possible, I suppose, but it is, it is an area of risk, and it's an area. It's one of the reasons why it is important to get the distinction right. Bear in mind, of course, what Alexi was saying earlier about the sort of question that actually even grant awards should, where possible, be competed, or at least competition thought about. So yes, an important area, and thanks for asking us about it.
I think we've just about time, so there are a few more questions left, but what we'll do is we'll pick those up and we'll circulate answers to them afterwards to all of the recipients. So thank you everyone very much for joining us today, and for your interaction and for your very good questions. You're keeping Chris and I on our toes, that's for sure. And we look forward to seeing you at the next ThinkHouse session.